So welcome to our session on conservatorships. And first of all, let me introduce the panel. I'm Brenda Eckert. I'm with the National Center for State Courts, housed in lovely Williamsburg, Virginia. And I'm here with Kate Boyko, who heads their conservatorship program and auditing program in Minnesota. We have Jeff Renard from Texas and Erica Costello from Indiana. So we have 1 hour, unfortunately, because we could talk for probably 10 days on conservatorship issues. So our challenge is going to be to try to squish this into 1 hour. Conservatorships are guardianships of the estate. We have, they're called different things in different states, but we use sort of a generic conservatorship label to mean guardianship of the estate. We use guardianship to mean guardianship of the person. So this is mostly about the financials. Start with the fun part first. How many of you have all of your estate papers in order? Powers of attorney, healthcare directives? Oh boy. Uh-oh, you're in trouble. Elderly parents have all this stuff in order? Go home and do it, because this is the scariest stuff that I've ever worked in. I've been working at NCSC for 15 years, and this is the most complex, varies considerably from state to state. The amount of abuses that occur, we don't even really know. The level of court monitoring, dismal throughout most of the country. So it's an area where I feel like I'm going back into the 19th century. Paper accountings, it's like you did your taxes hopefully in April. Be like you went to the library and you got that paper 1040 and you filled all that in and then you mailed it in, right? How many people did that? Oh, wow, okay. But it's like going back to, there's no technology, there's no software. So this is, we're trying to move the field eons forward. So this is a project that we have, that we've got 5 pilot states now trying to develop this technology. But it's really about, what if we take technology and we apply it to conservatorships? So one thing we want to do is modernize the process. So rather than somebody filling out a form and submitting bank statements and receipts, is there a better way to do this? The other piece of this is auditing. How many of you work in courts that handle conservatorships or guardianships? A couple of you. Are they audited? Are the accountings audited? Yes? Yeah? By whom? The clerk's office? Okay. That's good. Most places, there's a checkbox if it's filed. I shouldn't even say that because I'm looking at David Slayton, so he can talk a little bit about, and Jeff can talk about Texas, because sometimes it's not even noted whether the accounting was filed, if it's filed on time, and very often nobody is reviewing it. So one of the things we want to do is automate the auditing functions. The other piece that happens is judges are not accountants, so they receive this financial information. We want to try to develop some response protocols, some guidance for the judge or the magistrate or who's ever handling these cases on, what do I do? What do I do when I find that, you know, Tom bought himself a $25,000 pickup truck out of mom's funds? You know, what do I do? And that's still a missing piece. And really what we want to do is protect the assets of vulnerable persons. You don't get to be the luxury of being under a conservatorship because things are going right. You're there because things have gone wrong. So these are vulnerable adults, and you want to protect their assets. So the Conservatorship Accountability Project, I'll call it CAP, much easier. Besides, we're the court, so we have to have acronyms for everything. So our goals are to really look at, develop tools that will allow us to sort of divert resources to those cases that need the most attention. Because right now, if you're getting 100 accountings, which ones do you pay attention to? Do you know which ones to pay attention to? Are they flagged? Do the flags work? So one of the things we want to do is develop the tools. The other thing is the other piece of this is the conservatorship software. So Kate is going to talk about the MMC, the My Minnesota Conservator, that they developed, that is the source code that's being adapted by the other states. And finally, what we want to do is, rather than each jurisdiction and each state redoing what Minnesota has done and what others have done, we want to create a conservatorship accountability, a CAP network, so that we share resources, we share ideas. If somebody figures out how to code this, the other states participating can also learn how to do that. And so that's the other piece of this project. It is funded by State Justice Institute, so if there's anybody here from SJI, there's your plug. So using predictive analytics to flag cases. So that's the first piece. So there are three pieces to how do you develop predictive analytics. So the first piece of this is to capture the data. So where's the data coming from? And we are very lucky because Minnesota has been very, very generous with their time, their resources, and their data. So they are the only state that has a statewide conservatorship software with statewide data. And they have audited, I don't know how many cases you've audited now, but we have a data set of 1,302 audits. And I'm looking at Scott, who's our statistical magician, and that's the number I always remember. So about 1,300 cases that have been audited. The question is, from those accountings and the audits, can we predict problem cases? So in Minnesota, they use 4 auditing levels, 1, 2, 3, and 4. So no problem with levels 1. What we're really looking at are the level 4s. Here, there's a concern of loss. So either it's there's something suspicious. It looks like perhaps somebody did go out and buy that truck, or sometimes what we find looking through those cases are family members who kind of pay other family members to provide some service. So there's all kinds of levels of exploitation that Kate will talk about later. But can we predict the level 4? So if you think about this, and you've got those 100 cases, if you know that you can pull out 18 cases, those are the cases you need the most attention, that's a great use of resources. So we used all these great statistical analyses, and Catherine and Scott, who are here, have plugged away on a lot of these different pieces to try to figure out if we can predict the level 4s. So Minnesota had a level, has a number of flags, and those flags were sort of based on anecdotal information. Like if you look at the flags that are out there, there are suggestions that a high level of a state, a high amount of money in your state, is going to lead to greater risk of exploitation. And first of all, is that true? We don't know. And it could actually be the reverse, because if it's a high amount of the estate, it could be more professionally managed. So all of those anecdotal flags they're good starting points, but none of them have been tested empirically. So our job was to take a look at that and to develop new, what I'll call risk indicators. And yes, thanks to all of those statistical analysis and our staff who worked on this, we were able to accurately predict 80% of the level 4s, which was pretty cool. We ended up with 10 preliminary risk indicators. They were indicators that we would not have ever thought of before. Number of clothing expenses. Not the amount of expenses, but the number of clothing expenses the transactions made. So there were a number of examples like that. Some of these were conditional. So if the person lived in a care facility, an indicator might be this. But if they didn't live in a care facility, that indicator didn't work. So we came up with 10 preliminary risk indicators. We are, and I haven't talked to Kate about this yet, but I think we're pretty close to getting these programs back into the Minnesota data set so we can actually begin to pull out some of these things. The neat things is we were only looking for level 4s. So it's like, okay, so we've got these risk indicators. Do they correlate with the other levels? So this is for researchers and statisticians. This is like, okay, I think we're onto something, because this is just a nice, a beautiful step of you know, how many flags per audit. So this suggests that we are doing a pretty good job of being able to predict the level 4s. As we get more data in and do more analysis, we think that predictive level is going to go up. The other piece of this is developing the response protocols. This is all brand new, so people are thinking of it as a technology project first. So you have your IT folks, and they're like, okay, how do we take this software? How do we adapt it to my state, to my jurisdiction? Then they get the software going, and it's like, uh-oh, now what? We still need people involved, so we still need somebody to audit this piece. The last piece is training the judges or training whomever is responsible for this on what do I do? So I've got an audit level, there's a level of risk, and so that's where we hope to move eventually, so that we move towards differentiated case management, so I can automatically pull out these particular types of cases and audit them more thoroughly. So that's where we're going to try to develop those response protocols. We, with the SJI funding, we were able to support 5 states, basically provide technical assistance. So we have 3 implementation states, Indiana, Iowa, and Texas. And then 2 of these states, they've got to do some data issues, and they still need to figure out which cases are open and which ones are not. So we call those planning states. That's New Mexico and Nevada. So the CAP network right now, it's an NCSC connected community. So the goal is to try to, again, share the resources. As one state develops something, that is shared with the other states. So what I'm going to do is have Kate talk about Minnesota. We'll have Jeff give us a little overview of Texas, and Erica, Indiana, and then we'll do some Q&A. I have some Q's, and hopefully they have the A's, and we're going to try to get you involved too, so you can have some time to ask questions.
There. Can you hear me now? Can you hear me now? Okay. Now I have to figure out how this works also. Okay. So to start out with, I'll give you a picture of what Minnesota looks like. We have 10 judicial districts and 87 counties. We are general jurisdiction courts, and in 2015 we had 5,575 conservatorship cases reporting in the My Minnesota Conservator application. In Minnesota, we have guardian of the person and conservator of the estate, and I'm talking specifically today about conservatorships in Minnesota. A very important number, if you are not doing anything as far as oversight of your conservatorship cases, the number you need to figure out is the dollars under court jurisdiction. This brings a lot of attention to your court administrators. In Minnesota, in 2015, we had over $900 million under court jurisdiction. This is greater than our court budget. It's a lot of money. In 2016, as of the end of June, we had 2,929 cases reporting in the My Minnesota Conservator application for over $500 million in assets. So get at that number. If you don't know what that is, that's a very important number. Let's see. How do I flip? There we go. The other piece that's going to get the attention of both the court and the public are these headlines. They're not good, and they bring attention to the court, and they don't make us look good. So what did we do in Minnesota? We started in 2005. One of our major counties, Ramsey County, which is the county where our capital, St. Paul, lies, decided because of a professional conservator that was stealing from their clients, decided that we needed some other way to monitor conservatorship accountings and came up with the CAMPER program, the Conservator Account Monitoring Preparation and Electronic Reporting System. And yes, I have to read that because I've forgotten what the acronym stands for. I think we created the acronym because it sounded cute and then put some words to it. For a very minimal budget, Ramsey County put the CAMPER program together. We already had a statewide form for reporting conservatorship accountings, and we took that form and put it into an electronic program where conservators could log on to the web and enter their data and then submit it to the court. Then the court went in, printed it out, and filed it. So it was pretty cumbersome. It was not much more than paper gone to electronic format. The next part of that was in 2011. Even though it wasn't that robust, it was still a lot better than what we had. In 2011, our court decided, this is pretty cool, we're pushing this out statewide. So it was made mandatory in 2011 for all conservators to file through the CAMPER program. The next piece that our judiciary decided was important is we can't just have these accounts filed and sit there. We do have court staff in various counties looking at them, but the degree to which they were being looked at varied tremendously. Some were checking off the balances, some were getting all the checks, all the receipts, all the bank statements and going through them. It varied tremendously. So it was determined that we needed a statewide auditing program. So the Conservator Account Auditing Program was formulated, which also has the acronym of CAP, in 2012. And I was hired at that time to start that program. With that, we took a look at CAMPER and went, well, this is okay, but it can be a lot better. So with the help of a State Justice Institute grant, we developed the My Minnesota Conservator application. And I'll talk about that a little bit more. And that's the application that we've made the source code available to anybody that wants it. It's not plug and play. You can't just take it and plug it in and go with it. You need to do a lot of work, which Jeff and Erica will be talking about. But it's there for you if you decide you want to take it. So why did we do this? Well, first of all, those headlines. We don't like those headlines. The other reason is our judicial branch's access and service delivery committee decided that we just needed more oversight. There was a lot of money under court jurisdiction, and we weren't looking at what was being reported, how it was being managed. We had very inconsistent practices from one court to another. In all 87 counties, we had over 87 ways of doing things. This was really frustrating for our professional conservators. And the other part is that case that went bad in Ramsey County, well, they discharged that conservator, but they were operating in the neighboring Hennepin County. Well, then they discharged that conservator, but a little farther south in Rice County, that conservator was still stealing. We weren't communicating. So now with a statewide program, we have communication in place that if somebody is bad in one county, we can get that word out. So what are the benefits? Oop. Oh. There we go. There we go. So what are the benefits of having the My Minnesota Conservator application and the statewide auditing program? Well, first of all, for the court, we have consistency. Judges look at the same report year after year. They know the format of the report. They know that it's detailed transactions that are reported. And from county to county, it's the same report. That makes their job a lot easier when they're having hearings on accountings. We have consistent practices. Getting compliance with filing annual accounts is consistent from one county to the other. We have a streamlined approach. If they don't file on time, we issue a notice to file or appear. If they fail to comply with that, we issue an order to show cause. And hold your breath, we have judges that issue warrants. So we have had people arrested for failing to file their annual accountings. We take this very seriously. There's also a uniform audit schedule, and the audit program is available at any time for judges and court staff to refer cases. What's the benefit for conservators? Well, some of our conservators don't use computers. It's difficult for them. Because of that, we have the ability for them to appoint an agent to do the data entry on their behalf. They can download transactions. If they use QuickBooks, Quicken, other accounting software, they can download those transactions directly into the My Minnesota Conservator application. So professional conservators that have their own accounting software, they can still use that. We have a helpline. This is very important. We have a helpline available for conservators to call to say, how do I do this? How do I do that? How do I enter this? I can't get into the system. We have a live person that can walk them through it. The assets, once they're entered in the inventory, carry over year to year to year. That IRA that got entered in the inventory is there in the annual account, in the first, the second, the third. It's always there, unless they do a transaction to get rid of it. You can't lose those assets. Detailed transactions are captured. Everything on the bank statement is captured. Every cash transaction, everything. Within the system, there are help videos to walk them through the specific screen that they're on. Within the application, there are automated notifications. The login to the system is capturing an email, and the system sends automated notifications to that conservator, reminding them of what they have to do and when they have to do it. So nice, soft. A lot of courts are used to hand-holding these people and helping them out. These soft reminders give them that, you've got 10 days to file, you've got 2 days to file, we give them 120 days to file. So congratulations, you filed, now you might want to work on next year. The other thing is we designed the application to be helpful for the conservator to manage the assets. So it's not just a reporting tool to the court, but it kind of helps them. They can look at the bank balance, and they can look at their balance on their bank statement, and they can make sure those correspond, and they can enter transactions weekly, daily, monthly, every couple months. So we really encourage that. And again, it provides consistent practices for professionals statewide. So the Conservator Account Auditing Program started in 2012. We do compliance audits on a statewide basis. We also provide education to the court staff, and judges, and we provide conservator education. Conservator education, we're lacking in this area, but we've recently received another State Justice Institute grant, and we're working with the National Center for State Courts to develop an online interactive training program for our conservators. And National Center has developed one for North Dakota, and we're following that model. It's an excellent, looks like it'll be an excellent program, and I'm really excited about that. Best practices, I have an advisory board of probate staff and judges from around the state that advise on what our best practices are based on our laws and our statute and our rules. And then we manage the My Minnesota Conservator application. So we're continually tweaking it and revising it to improve it to better fit our needs. We audit every 4 years, starting with the first annual account, and court staff do an examination overview in between those years. Why is that? Our statute requires hearings every 5 years, so it's within that hearing cycle. Is it the best case scenario? No, but it's what our budget is allowing for at this time. Also, court staff and judges can refer cases for audit at any point in time, and they do. I'm going to skip over those two. This is just a snapshot. Brenda alluded to the 4 levels that we have. Level 1, everything's okay. Level 2, the accounting's a mess, but once we audit it, it's okay. These are the people that can't balance their checkbook or never have. Level 3, there's some issues, but no real concerns of loss. And level 4 at 8% is concerns of loss. Our level 4 cases, concerns of loss, have varied between 15 and 8%. So they fluctuate on a regular basis. This is our 2015 results. So I'm going to give you an example of a case that we audited. So this is just one example of thousands of cases. It's a level 4 case. The protected person lived in a care facility and had a traumatic brain injury. The daughter was appointed as the conservator. The daughter, interestingly enough, was employed as a business coordinator at a care facility. Well, wow, you would think she's a business coordinator at a care facility. She knows about a care facility. She's, you know, she could handle this job, right? That'd be no problem. She was initially appointed as an emergency and then on to the general conservatorship. In Minnesota, we have emergency conservators. There was no bond on this case. Our statute requires a bond if the assets exceed $10,000, or there's an alternative method of protecting the assets, such as a protected account. Our judges are not always issuing bonds. We're really working on education to get bonds on all our cases. If you can't audit, you need, and even if you can audit, bond, bond, bond. That's what our judicial officers need to do, is bond. So an audit was completed on the first annual account that was filed, and it looked great. Everything was okay. The receipts, bank statements, everything balanced. It was very good accounting. The second annual account was filed, which would be the responsibility of court staff to look over it. And they saw that there was a 58% change in expenses. They increased by 58%. That's kind of odd. So, I don't know if we have do we have a laser on here? Yeah. So, A is where the conservator lived. B is the care facility where her dad was. C is where I'll show you some receipts from, and the red circle indicates the primary shopping area where all of the expenses were incurred. So what did we find? We found that there was inadequate documentation for over almost $15,000 of expenses and cash advances. The purchases were all made within that red circle, were mostly made within that red circle area. There was $11,000 for clothing and department store purchases. Okay, we have a man with traumatic brain injury in a care facility. $3,069 in restaurants, $109 at the hair salon, $200 at a car rental, $388 in late fees and interest expenses, $1,900 in personal needs, and the care facility informed the auditor that the care facility was funding the personal needs because the conservator was unresponsive and rarely visited the protected person. The conservator had no receipts for expenses, and the room and board at the care facility was unpaid. Now remember, what was her profession? So this case was, oh, there we go again, right? So I'll show you here, this is a credit card statement. So she went to Bungalow Bangles, which in looking online, we see bathing suits and accessories. You need that when you're in a care facility, right? Yeah. And the House of Amour. Well, fashion meets faith. Our store is more than a woman's clothing boutique. You wonder where that went. So, what were the results? The probate court issued a temporary substitute conservator and a judgment of over $24,000. It was referred by the judge to the prosecutor. The daughter was charged with financial exploitation of a vulnerable adult, ×3, received 2 years probation, 100 hours of community service, a 1-year sentence stayed, and required to pay restitution. So, like I said, this is just one example of many. And what I will say to you, if you're not looking, you have no idea what's there. And it's better to look and know what's there than to be surprised by something that appears in the headlines in the newspaper. So with that, I'm going to turn it over to Jeff, who's going to talk about how Texas is implementing the My Minnesota Conservator application. Yeah.
Good morning. Can everybody hear me okay? I want to give you a quick overview of the Guardianship Compliance Project in Texas and what we're doing. And if you hadn't had a chance to get with Minnesota and see, we've actually been to Minnesota, we've visited with Kate's staff, and if you're thinking about this in your state, it's something that you need to do. She has an awesome staff. They're doing a great job. The Guardianship Compliance Project in Texas, what we're doing is we have several phases to this. We certify guardians in Texas, so they actually have to take a test. So if you're a private professional guardian and you work out in Texas, you have to take a test and be certified through us and renew your license, and you have minimum standards you have to follow. The second part of what we're doing right now is we're trying to adapt to Minnesota's electronic application. So we want to take that to Texas. We want them to be able to file these inventories and annual countings and reports online with us. And then we would have auditors look into that. We're also looking into registering all guardians in Texas. So there's a project that we're working on where we're looking at the feasibility of registering guardians. So we would know all of the guardianships that are going on in Texas. And the fourth phase of this project is we're thinking about taking this, we're actually doing it, it's in our strategic plan, taking this statewide. So the whole state of Texas is covered by this project. In Texas, I'll give you a little landscape. We have 254 counties in Texas. 10 of those counties have 18 statutory probate courts, meaning that they have courts that specialize in these guardianship matters. The other 244 counties do not have that, and those cases are heard by the county judges. So as you know, we're not unified in Texas, so there's 244 ways of doing, actually there's 254 ways of doing things in Texas. We have 53,000 guardianships that are reported to us. We don't think that's exactly accurate. It's probably more, it's a little high. It's probably about 45,000 guardianships in the state. So you can see we have a lot to deal with around the whole state. We're estimating that it's about $2.5 billion under guardianship in Texas. So what are we doing? On the recommendation of our Judicial Council and my boss, David Slayton, and the Office of Court Administration went to the legislature during last session and asked to start this guardianship compliance project. We asked for 6 auditors to go out into the counties, work with the courts, work with the clerks, to review these guardianship files to see what's going on in Texas. So some of the things, before I talk about that, though, I want to just talk about how this, it's not just data and case management system and these other terms we're talking about with electronic systems. It's a person. How it's affected me personally through my life. I had a grandfather who was very active. He walked 2 miles in the morning and 2 miles in the afternoon, and he was walking along and just fell and hit his head, had a serious brain injury. He died 6 months later, had to be put under guardianship. And so it's something that affects you. I also had a grandmother with Alzheimer's, and I currently have a mother-in-law that we're dealing with Alzheimer's. So these cases are very emotional, and so we've been out looking in these files, and they're very tragic. Every case, and they go on forever. So you're talking about a case that could last 5 years, it could last 40 years. So it puts a lot of strain on the courts and the clerks. So we have a lack of resources and personnel to handle these cases. And I think a lot of times what we're looking at is if there's no complaint, then it's easier for them to just go on with other matters that they're dealing with in their court. So that's one of the things that's been a real eye-opener when we're looking at these files, because I'm out there with the auditors and I'm looking in the files, and it's just a tragic situation. You have a minor who's lost both parents, one or both parents. You have an adult who's been in an accident. You have an adult with cognitive disabilities or Alzheimer's. So every file is tragic, and you have a lot of emotion. We also deal with the certified guardians. We investigate complaints into certified guardians. So certified guardians in Texas private professional guardians are kind of a last resort. When someone else can't do it, they do it for them. And so when we get complaints involving them, there's a lot of emotion from family members, and you can see there's a lot of tragedy involved in all of these cases. So when you're looking at them, it's easy to think, oh, it's just a file, we're talking about data, and we're talking about electronic systems, but it's more than that. It's not just one person's life, it's a family's life, and everybody who's dealing with this. So what we've done in Texas, we've hired 3 auditors. We're currently working in 6 counties, and we're looking at going into to 2 more counties soon. And we reviewed about 2,100 cases so far, and basically we're collecting about 56 points of data throughout the file. And in Texas, we have, it's not unified, we have case management systems are all different. So they may not have one, or they may have the best one you can think of. So it's just every county's different. So when we go out there, in one of the counties recently, we were in, it was 1,200 cases we reported, and we had to look through paper files for every single one of them. So to find the data, we had to look through 1,200 files and look through every single piece of paper in there to figure out and populate the spreadsheet. So we've looked at about 2,200 cases so far, and I think by the end of this project, we'll probably review, I don't know, 15,000, 20,000 cases by the time it's all done. So what they're doing is they're reviewing the files, and they're looking for missing inventories, annual reports, and annual countings. And the ranges in the counties, they're all different. So in some counties, they do an excellent job. In Montgomery County, the court administrators here, we review their cases. They're not reporting high. All of their filings are on time. And then you go to another county where you have 90% of the inventories are missing, the annual reports are missing, and the annual accounts are missing. So there is a real problem that we're trying to deal with when we take this statewide. Another thing we need to do is, in January of 2017, we've got to make this report back to the legislature. They want to know what we're doing with this, so they're going to want to know how many counties we were in, how many courts we looked at, how many cases we reviewed, and then what we did to help them with the audits. Sorry. And then going forward, our strategic plan, we just did that for OCA recently, and that's one of our goals, is to take this statewide. So we're going to ask in our legislative appropriations request to take this project statewide. We're going to ask for 40 people to go out there and try to have compliance around the full state of Texas. So at this time, I'll turn it over to Erica, and she can talk about Indiana's.
Thank you so much. Can everyone hear me? All right. I'm going to go ahead and just do my presentation from my seat. For this person from the mic gets to do that. My name is Erica Costello, and I am the staff attorney and the head of the Adult Guardianship Office at the Indiana State Supreme Court. So one of the things that I kind of want to give a little bit of background about is what our office does. Our office was just created in 2013 to look into providing programs with funding from the state legislature to start up adult guardianship programs throughout our state, as well as to start up in what we call the guardianship registry. And so for those who aren't familiar with Indiana's guardianship registry, what the registry does is twofold. First, it provides a tool for the courts, which allows them to track the number of cases that they have within each of their jurisdictions. And it also allows the public to know who is under guardianship in our state. And so for those counties that are participating in the registry, which right now is a voluntary program, it's not something that's mandatory for all counties in our state to do, our guardianship registry really does help out in a lot of capacities. Prior to the development of the registry, we didn't know, for example, how many adult and minor guardianship cases we had in our state, and the registry now is able to distinguish those types of cases, as well as distinguish the types of cases of guardianship that people are under. For example, we can now count the number of guardianships of the person, guardianships of the estate, or guardianships of the person and the estate. So it really does help with collecting those types of data points that we weren't previously able to collect. It also notifies the court when certain things haven't been done. So for example, if a guardian ad litem, I don't know how many of your states require the appointment of guardian ad litem in guardianship cases, but one of the things that our courts had particular concern about was whether a guardian ad litem had been appointed in those cases, and the guardianship registry will actually provide a tickler for the courts if a guardian ad litem has not been appointed in those cases. It also has a place in the registry to notify courts when inventories and accountings are due. So one of the things, again, that the courts were looking at was, in some cases, they found that inventories and accountings just hadn't been filed, and they didn't know that they hadn't been filed. So now we have a place that allows them to be notified when things are due and when they're not due, and they can look at requiring status hearings if an inventory or an accounting hasn't been filed, and have those people come before the court and provide those filings. So just to give you that background, because that's where we were at prior to applying for this grant. And what we wanted to do with this grant is really look at integrating our guardianship registry application with Minnesota's Conservatorship Accountability Project. And so what we're looking at creating in Indiana is what we call MENA, or My Indiana Accounting Project. Trying to come up with some cute acronyms there. And really what's really been great has been, once we got the source code, we found that we were able to integrate both of those platforms. I'm hoping I'm using the right technological terminology. I'm probably not. But we were able to use the data that we've been able to obtain from the registry and use that for purposes of that application that Minnesota has. And so those applications will be working together to help out courts with the filings of those inventories and accounting. So now that MENA will provide people who have been appointed as guardian the opportunity to apply or to file online their accountings and inventory forms, which will then go through the registry, update it, and alert the courts to the fact that those documents have been filed. And then, of course, with all the wonderful things that Kate has been talking about that the application will do in allowing the court to then look at the possibility of those red flags and indicating whether there's some type of financial financial abuse or mismanagement that's going on. So we're really looking at those two programs working together to try to prevent the types of financial abuse and exploitation that can go on in those types of cases. Just so you know, in Indiana we have 92 counties. At this time, we presently have 38 counties on the registry, which is, I think, pretty good considering, again, it's a voluntary program, and that's a little over a third of our state in the last year and a half. So we're making some headway, but obviously what we're hoping to do, kind of like Jeff had mentioned in Texas, is taking this statewide, as well as having the application that we develop with MENA, which will then go statewide with the registry. So those are our goals. And one of the challenges that we're kind of coming up against, I don't know how many of you guys are looking at e-filing, but e-filing is definitely something that Indiana is gearing up for. And as part of our pilot project site that we chose for our to implement the MENA project is one of the sites is going to be undergoing e-filing starting in September, but all of the counties are set to undergo e-filing by 2017. So we're slowly but surely rolling that out in our state, and I know that that's going to probably cause a little bit of, I don't know, organized chaos, if that's the exact terminology for it. But anyways, if you have any questions about our registry or our progress in the development of this application, that's purely where we're at right now, is in the development phase. We're really hoping to be at the implementation phase and sometime later this fall. Especially, like I said, with looking at working with our pilot county in the e-filing later in this fall. So thank you so much, and I'll go ahead and hand this back over to Brenda for question and answers.
Thank you so much, and time is flying, so I have a whole list of questions. I'm only going to ask 2, and I want to give you some time to ask questions as well. So one of the questions is about piloting this program. So if I'm going to select a jurisdiction, a county to pilot this in, what are the types of things I should be looking for?
Okay, so when we selected our counties for piloting, we definitely looked at the issue of e-filing, like I had mentioned. The other thing that we wanted is we selected one county that was already using an auditor or an auditing system, and the other was not using an auditing system. And I think that that's kind of important because a majority of our jurisdictions do not use auditors. And so I think that that's going to be another new element that's going to be part of our pilot projects that we're going to have to be working with, and trying to look at how we're going to implement those auditors is another thing that we're going to come across. One idea that we had was the possibility of using senior judges. I know that Kate has her own system at the state level. I know Jeff's looking at using people at the state level as well. So there are definitely some ideas that you have if you have the funding for it, but I guess it does come down a lot to the funding.
And to implement the project in Texas, what we looked at was counties that had reported a high number of guardianships who are not statutory probate courts, but we've been lucky because a lot of the courts have volunteered to do this, so the judges have been very cooperative. They've come to us, basically, so we've been very lucky in Texas with the pilot.
I'll leave it with that answer.
Okay, the auditing piece, it's one of the areas that's generally neglected now, so we've got staff and or judges who are often responsible for reviewing this without any accounting background whatsoever. So it's a resource issue. A lot of the pilots now are just like, okay, we're getting to the technology point. We've got to figure out that we can't totally automate this. If we just tell a judge, oh, it's a level 4, what is the judge supposed to do? So I know Kate has an innovative way to that they use to support their auditing team, but if you can talk a little bit more about the importance of auditing and how that's got to be planned out and figured into the equation.
Sure, I'll get on my soapbox here. I think the auditing piece is essential. The filing is important, but what is filed may not be the actual picture. Or it may be the picture. But you won't know unless you look. And it seems to be that in conservatorships, there's a right to the money, especially if it's family. I'm going to get it anyway, so what difference does it make if I spend it? In the case example that I showed you, when the conservator was interviewed by the police, she said, well, I paid my dad's bills, I just used what was left because I thought it was mine. So we need to look at this. Vulnerable people do not have their own voice. The court puts them under court jurisdiction because they are vulnerable, and we have a responsibility to them and to protect their assets to make sure they're spent for their benefit. Auditors must be trained, must be qualified. My staff are MBAs, CPAs. I have many of my staff that have their certified fraud examiner certification. There's a lot going on in these accounts, and we need to take responsibility and look. I currently have 6 full-time staff, 3 and 4 part-time staff. One of those is the helpline person, and our budget is paid for by federal 4D money. Minnesota took on a project a few years ago to hire somebody so that we could reap the benefits of the federal 4D money, and we use that to fund the conservator program.
Tell them what federal 4D is.
It's the child support money, and so it's something that I can give you more information on if you want to contact me.
And then to follow up, do you think Texas is going to provide 40?
I hope so. That's what we're going to ask for, and I think it's important. I think we have legislative support already. I think that the Judicial Council is on board, and I think that it's very important. We have to do something about it now because of our aging population. We have to do it now, so I think it's something we have to do to be preventative. Also, I want to piggyback on what she said. I think there is from our review, there is an idea of this right to the money that's not theirs, and they spend the money that's not theirs. We've seen. And we hired auditors with auditing experience first who really did not know anything about guardianships. They had some knowledge of it just peripherally, but nothing where they were actually working in the courts or doing some stuff with guardianships. We looked for auditors who were qualified to do that. And just a lot of our cases that we're looking at, we can't even audit them because there's nothing to audit. They don't give us the data. And a lot of these cases we found have been approved by the courts and judges that have never been audited. So they turn in the piece of paper with no receipts, no backup data, and they're approved. So if you get approved every year and you're submitting these things, it makes you more brazen. So it's something that we have to get a hold of now.
And I'm sure Pennsylvania is going to be on board, right? So I want to just, before I want to say, this is, we're trying to make it relatively easy for anybody to launch this project. So Kate has an agreement, and all you need to do is contact Kate and you can get the source code. If you do implement this, we can add you to the CAP network. That will give you access to all of those other resources, so you can look around in there and look at, right now the discussion is a lot of it's on IT, but you'll find resources there. So it's really available for any jurisdiction, local, regional, state. So if you are interested, please just let us know. Other questions?
Actually, one question, primarily for Kate. I'm from Florida, Tampa. Our circuit thought about, thank you. Our circuit at one point entertained the possibility of having a standardized reporting system primarily for the accountings. We got a lot of pushback from the professional guardian conservator community and from the legal community in our circuit. To effectuate your system, did you have to do anything statutory or anything in an administrative order to require people to use that system, and how well did that go over with your professional community?
I think that's a really good question. Thank you for asking. Our state court administrator mandated it. Our statute was vague enough that was, and we have now implemented it into our rules, which is very similar. We just went live with mandatory e-filing. So it's in line with e-filing. So if your court's going towards e-filing, this is just another method of e-filing. As far as getting the professionals on board, we have a professional organization, and we worked with them and liaised with them and brought them on board and brought them to the table. I think it's really important to bring your stakeholders to the table and get their input on what you're doing. I think a very important thing to note from our professional conservators is they feel that this brings integrity to their profession because they're held accountable. And I think that makes a lot of sense. I mean, it is a profession, and they should be held accountable. So for the most part, they're very supportive and they're on board. But we did work hard to bring them to the table and to liaise with them.
This is really exciting, but I realize that it's also the tip of the iceberg, that the courts also are responsible for probates. Probate estates have lots of money in them. Probate administrators or personal representatives have annual reporting obligations. Probates can go on for a long time. So the same auditing principle should apply to the much greater amount of money that is under court supervision through the probate process. And then I'm aware of all of the trusts, the revocable trusts that are being created to avoid probate, which when they're created, the protected person is competent, but when they're administered, they may not be, and over time, ultimately, will never be. But those funds are not formally under court supervision in any way. There's no obligation to record a revocable trust. But the possibility of fraud is every bit as great in those environments as well.
That's a very good point. One of the things that, and yeah, we know that there are a lot of abuses. We get asked sometimes, can I modify this to include some of those other pieces that at least are under the court's jurisdiction, other probate matters? And yes, it can be, but I work with the Conference of Chief Justices and Conference of State Court Administrators, so one of the things they're interested in is abuses that occur under powers of attorney and outside of the court's domain again. And so we did a little research review. We interviewed all the experts in the field and what can we do, and the fact is not a whole lot, but there is increasing concern from probate judges. I've get asked, I handle adult guardianship cases, but then there are these trust matters, and they're in another part of the court, and shouldn't I be able to wrap this together? And I think I agree, we're at the tip of the iceberg, and it's very confusing. I'm trying to encourage Kate to do a research project on trusts. So, yes. Is that your okay? Is that your jurisdiction in North Carolina? Okay, there's the recipe. So, any other? I think we're about done with time. But thank you very much, and please, we encourage you to work in this important area and ask us questions as you like. Thank you very much.